Welcome to the Second Bite podcast, where we talk with top entrepreneurs and CEOs about creating valuable companies through creative transactions. Now, let's get started with the show.
Welcome to the Second Bite podcast. I'm your host, Todd Taskey, and today we are going to school. We are going to law school, actually. Robyn Siers is my guest today. Robyn, so happy to have you with me.
Thank you for having me, Todd.
This is really going to be helpful because, and we'll do an introduction to you, I think would set a good backdrop, but the legalese to a deal has a lot to do with eventually how much people will collect or not collect on their deal, whether it's escrow, whether it's earnout, whether it's equity, or a little bit of all of those things. It also exposes people or minimizes liability for entrepreneurs in a transaction. It's a whole bunch of things. I want to touch on, in the time that we have, we're going to take 2 or 3 hours of conversation and try to pack it into 30 or 40 minutes. So why don't we start, Robyn? I know you came from a big firm. You do a lot more transactions in a year than most M&A attorneys do. Give me a little intro and how you got to where you are now.
Yeah, sure. Thanks, Todd. So I actually started as a product manager. So I was in marketing and sales and PR and an entrepreneur for 10 years before going to law school. We started a .com that we flipped out of a larger company. We got acquired by Marsh & McLennan in the early 2000s. And so I've sat in the seat of seller and I've sat in the seat of founder. And I think that I'm told that gives me really great perspective when I'm working with buyers and sellers. So from there, I went to Berkeley Law and was recruited by Cooley and really grew up as an attorney under the great guidance and mentorship of the folks at Cooley.
Cooley's a big top 10 globally known law firm.
Yeah. And got a call from the GC and assistant GC of the first company that I worked for in Austin, Texas. And really, they kind of tasked me to say, what would M&A look like if you put your product manager hat on? You know, how would you do things differently? How could we, scale, and how could we find efficiencies? And that was just a really interesting problem for me to, leave Cooley, who I actually still work with on a regular basis, and say, what would M&A look like differently with some flexibility? And we went and built a program. We do 85 to 100 deals a year. And we've got a global team that we work with. And we're able to help both buyers and sellers. And I think by helping both, it really gives me perspective for each side, right? I'm able to remind buyers of how sellers are feeling in the deal. Because at the end of the day, even though we're going to look at numbers first, we're dealing with people. And people,
especially in the size transactions that right? We do, right? Yeah.
Right. We're dealing with people, and people are not always rational. Numbers might be rational, but people aren't always. And so perspective, I think, is so important. So I moved over to JonesSpross, where I am now. We're a boutique firm. We're based in Austin, but like I said, we have a global presence, and we really focus on providing efficient, strategic guidance to buyers and sellers in these deals.
And you talk about efficient. And so I don't know how many did last year, 60 or 80 or 100. How much of those deals are the same? As a rough percentage? And I know the difference is the most important part, but how much of it is the same that allows you to actually streamline the legal process?
So on the buy side in particular, we're able to really streamline that process, because when we have buyers doing multiple deals, our goal is to establish their provisions with a couple of changes and then deliver those to every single seller. And we're able to do that on a very consistent basis. We've also built a robust diligence team so that you have privacy support, HR support, tax support. And what's interesting is when I represent sellers, they just get the benefit of that team, right? I'm working on a deal right now where we're talking about some HR matters. Well, if the buyer is going to dig deep somewhere, you're going to want to have that support on the seller side. And a lot of times with some of the deals we do, there isn't that breadth of availability from the lawyer that's representing the seller. And so I think one of the value adds is really to say, do you have the breadth of support that you need to get the deal done? And that plays into that efficiency. The other part of efficiency is, what do you focus on, right? I'm all about saying, let me figure out what you, client, care about. And that's what I'm going to go fight for. I'm just not going to spend a lot of time on these other items. And I'm going to let you know, like, in the market, I know you really want this, but you're probably not going to get it. So let's decide, like, where are we willing to trade? And let's focus on closing and getting the deal done fast and getting the cash in your pocket, or getting that, strategic acquisition into the tuck-in as quickly as we can.
And so getting a deal closed is what we'll spend the rest of our time talking about. But it begins obviously with me as the banker. And we start to formulate the deal that we are going to eventually consummate with a letter of intent. And a letter of intent is, probably 3 or 4 pages of highlights that somebody like you and your counterpart will turn into 70 or 80 or 100 pages. Talk about what you as the lawyer try to accomplish with a letter of intent, and how quickly or at what point you'd like to be involved in that process.
Sure. So first of all, I have to say, having someone like you as part of that process, I will tell any seller, is you will end up in a better place. And I actually tell everyone that they need to talk to you personally, Todd. So appreciate
Excellent.
that.
Thank you.
So apart from that, I think, what you and I know about every deal, as you said, is it's economics first and liability second, right? How much are you still going to be on the hook after we close for any problems of the company? And it's a balancing act of how much is negotiated in the LOI versus getting the LOI signed and getting people involved in the deal. We often use the lingo, right? You're pregnant with the deal. Like, once people are involved, once people are spending money, they're just more likely to bend in certain ways to get a deal done. And yet a seller has the most leverage at the stage of the LOI because they haven't entered into exclusivity yet. So part of it depends on the seller. I have some sellers that say, Robyn, as long as I have the right economics, I'll deal with everything else after. I want to get locked into this deal. And then I have others who say, you know what, this is kind of my last hurrah, right? I'm going to get the second bite, but this is really my last hurrah. I want to be able to sleep at night knowing exactly the amount of risk that I have, right?
So the guy or woman who says to you, just get me the economics and the rest we'll deal with. If you were to say to them, whoa, let me get these 2 things accomplished for you in the LOI, what would those 2 things be?
Depending upon the size of the deal, if I can get reps and warranty insurance, I'm going to do that.
Okay.
If I can get that sort of covered in the LOI, I think that's almost, the most important. And then what is their deal? Because economics, right? The economics has multiple parts to it. It's, how much am I getting at closing? Is there some kind of an earnout? Is there any rollover? And am I part of the deal, and what's my deal? And I will actually say that most of the time, the seller employment agreement is the last thing that we get, and everybody's scrambling, right? Or that key employee agreement is the last agreement we get. And that's the thing that I would say, get out ahead of it, right? Make sure that when we think about
employment agreement,
make sure you're covering all of the aspects of your economics, because people get so focused on the purchase price that sometimes we forget about these other pieces.
Yeah. So let's talk about rep and warrant insurance. So maybe just, take it from the top level. Why does it exist? What is it? If we don't have rep and warrant insurance, what's the solve for that? Just kind of walk me through, please.
Sure. So reps and warranty insurance is your car insurance for the deal. That's what I always tell people, right? So you pay a premium to be covered, and you never plan to get in a car accident. But if you do, someone else is paying the bill after the deductible. Reps and warranty insurance works the exact same way. So no one's planning on any issue after the closing that relates to when the seller was running the company. So what can come up? Disgruntled customer ends up, saying that there was a breach of contract that happened before closing. Upset employee says that, their wages weren't paid correctly before closing. The IRS shows up and says sales taxes weren't paid correctly before closing. Those are the kinds of things that that may come up after closing. And the question is, who should pay for it? And at what point should it just be buyer's responsibility, right? And most buyers will say, not my problem. Happened before closing, happened on your watch. And so for a seller, that insurance says, well, it's not going to have to come out of my proceeds. There's going to be a small deductible, which is usually about 1% of purchase price. And then ideally the insurance company is going to cover it. The other really interesting part about insurance, we've seen a rise in reps and warranty insurance over the last several years. Before, you really didn't see it in deals that were kind of even 80 million, we started seeing it in sub 50 million. And now we're seeing it in 25 and $20 million deals. And the negotiation, the amount of money you spend on lawyers actually is reduced because we're not negotiating a bunch of indemnity terms that are coming out of the pocket of the seller or the buyer.
Yeah.
So there's a lot of value there. Now, I will say that when I talk to buyers, they do sometimes say, I feel like I'm spending a lot of money and there's not, we're not making any claims. But again, I just say it's the car insurance analogy, right? No one pays for car insurance and expects the accident to occur.
And the alternative to rep and warrant insurance is that, so rep and warrant insurance, from my perspective, comes about because we've got roughly 60 days-ish to do all of our due diligence. I'm sure you could hide stuff as good as we are for some period of time. And even if it wasn't hidden, the fact that a customer 3 months after close or 6 months after close is upset about something, how are we supposed to manage that? I paid you $10 million at close. You've paid your taxes. You've invested it. You've done what you have with that. But now we've got a claim of $250,000. Where's that going to come from? So if it doesn't come from the insurance company, we're going to keep money in escrow. So of the $10 million at close, maybe I only gave you 8.5, and I put $1.5 million into an escrow account. Can you talk about what goes on then? Like who gets to access it, what the time period is, how do you put a claim against it? What's your experience there like?
Yeah, certainly. So depending on the size of the escrow, a lot of these buyers are actually asking for holdbacks instead of escrows because they don't want to.
Talk about the difference there, please.
Yeah, sure. So in one case, you're actually putting that cash into an account that's managed by a third party.
The buyer's doing that. So
the buyer is doing it. Yep, go ahead.
Yeah, so I'm not giving you 10, I'm giving you 8.5. I'm still writing a check for another $1.5 million to give to the escrow company.
Right. And that way the seller knows that that cash is there, right?
Yeah.
And so let's start with that. So in the escrow case, it's going to go to the third party. And there's an escrow agreement that is a map for everybody to know. What do you do with that money? When does that money get released? Historically, a year has been kind of the market term. In sort of the lower end of the deals, the mid-market, we do see 18 months, 24 months, I think is really the highest end. But normally that's also tied to the survival period for the representations and warranties that the seller is making in the agreement. So what we say is that every agreement is about an allocation of risk between buyer and seller. And over a period of time of the buyer owning the company, the risk shifts to buyer. And so we say, okay, if one of these customer issues comes up in the first year, seller, you're going to pay. But after that, buyer's had the company for a while. They've been in charge. Now we're going to shift the risk to buyer. And now buyer has to cover it 100%. That's what those survival periods are really about. At what stage of the game do we shift risk from the seller being the owner of that risk to the buyer being the owner of that risk?
So if I can pause there for 1 second, let's just take the customer thing. At close, if I'm the seller, I am making a statement that says, I am not aware of any customer complaints or anybody that's upset and angry with us. Doesn't mean that somebody hasn't told me, but that's the claim. That will last, that representation I'm making to you will last for some period of time.
Correct.
And it's usually a year, 15, 18 months, something like that. And we want it shorter, they want it longer because why wouldn't they, right?
Right.
And then if there is a claim, who handles the legal expense of that claim? And then what if we lose versus what if we win? And what if that happens in 10 months and the claim is still floating out there and it lasts past the end of the 12-month escrow?
Yep. So to answer questions in reverse, as long as the claim is made within that survival period, a pending claim will toll the survival period. So it will continue until that claim is done.
Okay.
So if the claim comes in the day after, buyer's out. But if it comes in on the day of or anytime before that, it counts. In the escrow situation, and in any situation, again, our job as lawyers is to make sure that the map of what to do and how to do it is in the agreement. Why are these agreements 70 and 100 pages long? Because it's insane. But what we're doing is coming up with what is the trail? What are the steps for folks to take if the unexpected happens? And so you'll actually see the guidelines of exactly what you're saying. So who represents in that claim? Who follows up with the insurance company or the issue? Who is going to pay for it? A lot of sophisticated buyers will say, I'm handling it. I own the company at this point, and then I'm going to make a claim and you're going to pay for it, seller.
Right.
A lot of sellers will say, well, wait a minute, I have amazing counsel like Robyn Siers, and so no, that's not going to work. I'm perfectly capable of making sure that this claim is handled properly. And in fact, I'm in the better position because I know the customer, I know what happened, it happened on my watch. And so I will take care of it. And I understand that I'm going to be covering those fees under the indemnity. And then we have this middle ground where the buyer says, okay, but there are certain circumstances where I have to protect my business. And so if it's a particular, claim that's going to affect our reputation, if it's with a material seller, if it's a criminal activity, then I get to take over. So you have these flavors of terms in every case. And it just depends on, are you on the buyer flavor, the seller flavor, or the compromise in between?
Yeah. And one of the criticisms is if there's a holdback or an escrow, that the buyer just sees that as a way for them to pay less money to the seller. Is that a fair criticism?
I don't actually think it is. And just so we're clear for everyone, the holdback is when there isn't a third party holding that money, but the buyer simply doesn't pay out that amount to the seller, continues to hold it, right? It's in their bank account or otherwise, and then pays it out on the terms that are required by the agreement. I haven't met a buyer who said, I'm doing this to not pay a seller.
I don't either.
Buyers are prepared, right? They're prepared to pay. But as a seller, you got to put the other hat on and say, if there's a problem, who should pay for this? Like, what's reasonable here? And when you have these survival periods, I think it's reasonable. What sellers often are concerned about are sort of frivolous claims or making claims at the last minute just because. Right. And so one of the things that, I tell sellers is let's look at the history of those buyers. Most buyers don't have big claim histories because they're too busy building value after the closing, I have to say.
And if you think about the analogy that we were just using, as I say to clients, do you think a buyer would rather pay $10 million for a really good company or $8.5 million for a really flawed company with legal complications? Nobody wants that. Everybody wants the good one, right? Yeah. And so that doesn't mean that there haven't been circumstances where the buyer gets into a financial difficulty or there's other items, and you want to have the guardrails that you're talking about to make sure that the buyer can't do nefarious things that aren't justified.
Yeah. And I mean, it's sort of like any of these stories, right? The few can spoil the many. And I think that as a general matter, our buyers and our sellers are reasonable at the end of the day. And they are both there to maximize their return, whether it's the first bite or the second bite. And that's really where they're focused.
So let's talk, there's really kind of three parts to the economics of a deal, right? There's cash at close, and that's pretty easy because that's going to show up in my checkbook tomorrow. Then there's the earnout, and then there's the equity piece. Talk to me about on the earnout, what do you find is the biggest problem standing between a seller realizing that and not? And what's language that you think is critical and that you always want to have in a document to protect your guys?
Sure. So earnouts are complicated. And I think that they have a good place. They've kind of gotten a bad rap, I think, recently. And so what is the point of an earnout? The seller says, my company is worth X. The buyer says, your company is worth Y. The seller says, but I'm going to have this great next 6 months. And the buyer says, okay, if you turn out to be right, then I'll pay you. The earnout covers the gap between what the seller wants and what the buyer's willing to pay on the day of closing. So it actually is a great tool. The issue is it's all forward looking, right? And so one of the challenges of the earnout, I think it becomes, of a couple different matters. It's all forward looking and nobody has a crystal ball. I think that the structure of the earnout is critical. As seller counsel, I would always advocate for a revenue-based earnout, right? The money coming in versus net of any other items. Because what do we end up arguing about? Well, there were more expenses. There were too many expenses. The buyer, put in a bunch of expenses that we didn't need. And the buyer's like, no, we needed those expenses to grow. And so that's an area that we get arguments in, right? So making sure that you have objective measures for the earnout is really critical, not just subjective measures. Our preference is revenue, even though we often see an EBITDA or a gross profit measurement. And when I see that, what I try to get in the LOI is that the business during that earnout period will be operated on a mutually agreed budget. That budget will be approved on an annual basis. And sure, we'll have, some kind of 10% leeway or what have you, but you get a lot less, you have fewer issues after the closing if folks feel like they're involved in the process, right? Other than to the extent that they've got to run the business after the closing. And so
I think that's such a great point that you're 100% right, number one. Number two, that conversation, if you have it with opposing counsel, is just way, way too late to not be people butting heads. We interject that so early in a conversation, right? And in my mind, we can do revenue, we can do gross margin, we could also do EBITDA, but it has to be clearly spelled out how it's going to be calculated. And if we're going to have an EBITDA-based measure, we will control the business during the period. It is fully understood, and I say it right at the beginning. We were going to operate this business to maximize the earnout.
Yeah, and that is pushed back on 100%. Like no lawyer on my side wants to take that. Nobody wants it contractually. Something interesting that I did that actually worked really well was we basically said that the principals were going to be in charge of the business as long as the business metrics were at a certain level. So if they dropped, it was like X% below forecast, then the buyer could come in and control.
This is what I like about working, right?
Reasonable,
And this is what is great to work with somebody like yourself, because there's always a counterpoint to the other side. I don't want to do that because what if you guys are effing it up and aren't running it well? Okay, well, then we'll do this, right? We want to measure off of revenue. What if you just start giving away revenue at no margin? All right, well, we'll put a margin requirement in there that if we go below X amount, you have to approve it. Because maybe we want to bring in a big customer and we have to give them a discount, right? There's 100 ways to get to the right solution if everybody recognizes we're working towards the same objective. If your objective is to set an earnout metric that we can't hit, we're not going to do that deal from before it even gets to legal. A banker should be able to smoke that out. If you can say to me, we want you to get your earnout, then let's talk about how we do that, protecting our concerns and making sure that you get what you want, whether it's revenue, gross margin, or EBITDA, right?
And I think a buyer signals what their real belief in the earnout is, and they're willing to be flexible and to work with us.
And the seller does as well, right? The nonverbal communication is really important from that standpoint. And then, there's a whole bunch of other ways. I know we've talked before about not having a cliff, right? So if the measure is 2 million of EBITDA at 1.95 million, you get zero. you're going to have a lawsuit every single time that occurs, right?
Yeah.
So we always build a ramp into that, and we could talk about that independently if somebody wants to reach out. Let's shift off the earnout piece, because hopefully people are getting the sense that there's a lot of complication to doing that correctly. And I think a lot of that complication is solved by having good formulas in your documents that say, here's exactly how it's going to be calculated, whether it's revenue, gross margin, or EBITDA. Now, on a lot of deals, and this is, what we focus a lot on is the second bite opportunity. So my client is going to get a big chunk of equity or a small chunk of equity, but a meaningful and important piece of equity in the business. And one question that comes up all the time is, how do I know how they valued their business, and how do I know that's right? How would you comment on that?
Sure. So, I call it reverse diligence. When you're, receiving equity, there's a certain level of reverse diligence that a seller is entitled to, more so depending upon the amount of equity that, here's what I say. Here's what equity is. Here's what a rollover is. It is the seller choosing to invest in the new business. The seller is writing a check. You are writing a check for $2 million or $5 million or $20 million. If you are an investor in that business, what information do you think you're entitled to? That is the information that every seller should get. And if I get back, I'm like, what are you talking about? This is your new investor who's putting in probably more than half of the other investors have put in. And
right.
So, we want to know about the company. We want to see summary financials. We want to know how you came to this number. Is there a 409A valuation? Was it the last round that you did, right? Give us this information so that we feel good investing in this company and the future of this company.
And you talk about signaling. Good buyers, sophisticated buyers that are entrusted with a lot of money, which is typically private equity, will literally make a presentation and say, let me show you what's going on here. Let me show you how we got to here. Let me show you where we're going to go together. That full transparency is something that they should come forward with quite willingly, right? From that perspective. In many cases, there's a board for the company, and then there's an investment committee at the private equity group that have both agreed on what the value of the equity is that you're participating in or owning in, right? So that level of sophistication exists, and you as the seller should expect that you're going to get that, even if it's an early transaction directly with a private equity group. Because the private equity group should say in their flow of funds, here's how much equity we put in. Here's how much debt we borrowed so that we're all going to pay back. Here's how much we spent to do the deal. Lawyers, accountants, a bonus for the private equity guys, all of it, right? And there should be that full transparency on the transaction. I agree 100% with what you've said, that I'm rolling $3 million of equity into the deal. When you roll it in, or you write a check, as you said, when you roll it in, you get a lot of tax treatments so that it's you don't have to pay capital gains on it until it comes out the other end. The thing that complicates this is the private equity group has made promises to their investors into the fund. They've made promises to their first acquisition or their platform acquisition. And so I want to get all my money back. The private equity guys are saying, well, you got a bunch at close, and we have responsibility to those people. With all that stuff swirling around, how do you manage that and make sure your client is protected properly in the middle?
Well, I think it's a combination of protection and setting appropriate expectations, right? Like a company, your company's getting acquired. That is step one. There is a new sheriff in town. You have got to be prepared for that. You now have a boss for the first time if you're sticking around. That's a hard one. I will say a lot of founders who are just founders true to their heart don't last very long for the boss. So there's a new sheriff in town. And as you said, right, they have certain commitments to other folks. And so for me, it's really about education. right? What is this waterfall? What can you expect? A lot of times for me, I always say, this is the Christmas present, and I hope it's going to be a great Christmas a couple of years from now. And then I say, okay, but where are your minority protections, right? Can they just amend this agreement in a way that you're at the very bottom of the waterfall and you are halfway through, right? Do you understand that they can go do whatever sale that they want? They can, dilute you however they want. But can we make sure that they can't hurt you differently than the way they're treating other sellers, for example? So there are ways that we can look at minority protections. Another common one is what we call the tag along. So that if the PE firm's going to go sell a whole bunch of their, ownership, and usually there's some threshold, then the seller can share right alongside that sale. So there are a couple levers that you can pull in order to protect, and those levers change dramatically based on how much equity you're actually rolling, right? If it's going to be a 5%, of a rollover, I'm going to say to the seller, look, this is icing on the cake, right? We're not going to get a whole lot here, but if you're rolling 30%, that's a lot. And now we're going to say, okay, we want to be involved. I've had folks roll, 30 or 40% and they get a board seat, right? There's a lot of different ways that we look at protection depending upon the amount of money and the percentage involved. And so we just need to set expectations the right way.
And I think that's really interesting, because I wanted to come back to the boss thing, because my experience with that is different. And I think it's different because of the role that my guys play. And I think if we sell a business into a much larger, a public company, which we hardly ever do, or a much larger enterprise, then you are now the regional vice president for Lower Manhattan. And you have to report to the boss, and you have to fill out TPS reports and on and on. That's one experience. And you should get a lot of money at close, because, right? And it's great because I had Andrew Kleidas from Digital Impulse was on the podcast, for people that want to listen to that. And we sold him last year to a company called Demand Drive. He loves it there. When he was on the podcast, he talked about, me doing this is how I am accelerating my growth into what I want to do. And he rolled forward a pretty significant piece. And what I see a lot of times is that from a private equity perspective, when they put these puzzle pieces together, what I need is for you to do what you've been doing. You have brought us a business that's doing 3 million of EBITDA, selling to whatever the case may be. I just want you to do that, right?
Yeah.
Do you work from 6 a.m. to 2 p.m. and then you coach baseball and then you work? I don't care. Do you work from home, or do you work from Florida? Do you work from Montana? I don't care. As long as you're producing what you told us you would, you don't really have a boss per se, right? And we've got a lot of folks that have been at places for years and years and years and love it where they're at. And I think a lot of that comes from the ability up front to have choice, right? Because if I can choose from a bunch of places, I'm not going to choose the bad place. I'll choose the good place. And I think their expectations are right in terms of the level that they're coming in at, and for the amount of money that they're rolling forward. And to your point, if I'm going to have 3 or 5% of the company, for an entrepreneur, I'm used to having a lot more than that. So I'll do my earnout period. I'll act like an adult. I'll go to the partner and say, maybe it's time for me to move on. And then you never get acrimonious, I'm leaving at the end of next week, and people are upset and shorthanded and the rest.
Yeah.
So that's my experience. What drives yours?
Yeah, I think that your sellers are the happiest sellers on the planet, Todd. I do. No, but I think that there's something that you do that I think is really important, and that is you really focus on fit. And I don't know that everybody always gets the right fit. And I think that's when you have the breakdown. I will say this. I tell clients all the time, especially when you're doing a second bite transaction. If you're selling the business and going to go retire, what have you, then you can fight over every last dollar.
if you're at a second bite transaction, you're looking for the next several years. You're looking for a partner. People use the analogy of a marriage. And I think the worst possible thing you could do entering a marriage is to pretend you're a certain way. Yeah. And then now I'm in the marriage. Now I have to act like this for the rest of our marriage together, right? So I tell clients all the time, just don't make up answers. Be honest and truthful. And if somebody loves you for that, that's your home. And if they don't like this or that, or they want to change the other thing, then we'll move on and we'll find a better buyer. We really will.
Exactly. Being willing to walk away is the greatest leverage any buyer or seller has at the end of the day. I have 4 boys, and so I always tell my clients to use their spidey sense. And I say, okay, we're getting to the end of the transaction. Like, I want you to sit, go get a cup of coffee, wine, tea, whatever it is that you do, and take a deep breath and make sure that your spidey sense says, this is the deal to do.
Feels right. That's good advice. Let me ask this last thing, and then we'll wrap up. If somebody's thinking about eventually I'm going to do a transaction, what can they do to prepare? Right. And give me just a couple simple things that I know maybe eventually I'll do something. What's a couple good hygiene things that I could start doing now so that burden is much less on me when the time is right?
Get a good M&A lawyer.
Yes. And at what time, Robyn?
Yeah. I mean, I think doing some of that earlier is smart. A lot of folks, don't necessarily know that they can use a specialist depending upon the size of the deal or the size of the seller. And there are great folks out there, and we're here to support sellers. And so, I always think earlier is better because you're building that relationship, right? You're not spending money with the attorney. You're building the relationship with the attorney. And right? I am all about the relationship. I'm about the relationship with the client, with the other side. That's how we make these deals happen. But the 2 things that are most important is get your financial house in order. Folks spend a lot of time cleaning up book records of sellers. Making sure you have a good accountant and getting your financial house in order is number 1. And then number 2 is, all of your contracts and your HR. So are all your contracts in one place? Are all your formation documents in one place? Because you're going to need to be able to deliver those to the buyers pretty quickly. So those are the 2 things that we say to start with.
Yeah, and I think it's as easy as setting up a Google Doc or a Dropbox account or whatever it is, and just adding them all to that, having your policies in one place. It'll just simplify your life, when you get there. I also think it is, probably every banker that I know has, for some reason, done a transaction with a lawyer that has done a deal before, as opposed to an M&A lawyer. And every single guy and woman to the person regrets that. There is, for example, we talked about escrow. Escrow percentage of cash is between 10 and 15%.
Yep.
We can argue between 10 and 15%. But if you come in saying the maximum we'll ever do is 5, I think the other side's like, what are we doing here? Nobody does 5. That's not even a thing, right? Having somebody that just knows, okay, listen, you guys wanted 10, but you have to give us this. We're not going to, if you want 10, if we want 10%, we'll go out to 18 months on the rep and or whatever. We'll haggle and trade, right? But if we can do it quickly, because I know you know how deals work, everybody feels a lot more comfortable, buyer and seller, that we're going to get to a closed deal without the lawyers messing it up and on from there. So I think it's the volume of work that you guys do is incredible. The fact that you've driven it to a process, I know not only do people get very experienced legal help, they also get it at a rate that, from the comparisons I've done, is a noticeable amount less, certainly than a firm like Cooley. And I don't even know that Cooley would do a deal of many of the size that we do. But can you confirm that? Do you get that feedback from others?
Yeah, certainly. And like I said, I'm all about playing well in the sandbox, right? And so where the specialists, where it makes sense to use a Cooley, I'll bring them in, right? I am all about like what's most efficient, what's most cost effective, and what's going to get the deal done. I mean, my close rate is like 99%. Literally the only 2 deals that we didn't close were because numbers weren't the same at the end of the deal.
Yeah, which happened on the seller's fault, correct?
Yes, happened on the seller's fault.
Yeah.
And that is because of the way that we set up everybody, right, for these transactions. And that we're able to leverage those relationships and leverage our experience to say, let's not spend a lot of time and money on this particular point because we're never going to get it, or we're only going to get it if we give on this other point. And I have worked with other folks, and interestingly, like each industry also has their norms, right? We've been doing a bunch of marketing agency deals. 20% or 30% of our deals last year were on marketing agencies. And buyers have been able to get, certain terms that you don't see in my tech deals. But if you're working with another lawyer, opposite, who's only done tech deals, they think these terms are completely ridiculous. And I spend a lot of time educating lawyers on the other side to say, let me share with you what's actually happening in this industry so that you and I don't blow this deal. The other thing I do is I empower sellers and bankers. Like, I want you to go negotiate the deal at the end of the day because the business people, every legal decision is actually a business decision. There's very few decisions that are sort of pure legal because it ultimately comes down to risk. And so I'm like, here are the 3 things that are left, Todd. Go negotiate what makes sense for this deal for your client. And then my job is to make sure that it's written correctly in the document. Right. So that after the closing, if something happens, all the expectations were met. And
that is a great place to end it, Robyn. So Robyn Siers, ROBYNSIERS, if you want to find her on LinkedIn. Also at the Second Bite podcast, Robyn's contact information, everything else is right in the show notes. So you can, and your email address, Robyn, is what?
Is robyn.siers@jonesspross.com, JonesSpross.com.
And as I said, all that stuff is in the show notes, so it's just a click away. Robyn, it's a pleasure when we get to work together. It was great having you here. Thank you for sharing your wisdom and your experience, and just a great episode. Thank you.
Thank you. Always good to spend time with you.
Thanks for listening to the Second Bite podcast. We'll see you again next time, and be sure to click subscribe to get future episodes.